Picture yourself walking into a federal courthouse to sue your own state government, not some other state, your state, the one whose name is on your license plate. It has wronged you. You have a claim that arises under federal law, and you want a federal judge to hear it. Now open the Constitution to the 11th Amendment and read exactly what it says. The judicial power of the United States shall not be construed to extend to any suit against one state brought by citizens of another state, or by citizens or subjects of any foreign state. Read it slowly, because every word is doing work. It bars suits by outsiders, someone from the next state over, someone from another country. It says nothing, not a single word about you suing your own state. So on the text, your case should be fine. It is not fine. The courthouse door is closed anyway. How can that be? The words are right there, and they are narrow. They describe one specific kind of lawsuit, an out-of-state or foreign plaintiff against a state, and yours is not that kind at all. Yet more than a century of doctrine says a state's sovereign immunity is far broader than the one sentence that supposedly created it, broad enough to throw out your suit even though you are one of the state's own citizens, broad enough to throw out suits that Congress passed a statute specifically to allow. So the question for this primer is exactly that. The 11th Amendment bars one narrow kind of suit against a state. Why did courts treat it as a broad shield of sovereign immunity it never mentions? This is Do It for the Case Law. Doctrine Deep Dives, Season 0. The amendments, one at a time, one sharpest gap each. Today, the 11th. Start with the phrase everyone uses for this. Sovereign immunity. It is an old idea, older than the country itself. The government cannot be sued without agreeing to be sued. You can only take the sovereign into court if the sovereign lets you. In our system, the states are sovereigns, and this immunity is theirs to hold. Keep that concept in one hand for the whole episode, because everything that follows is about the distance between that broad idea and the very narrow words the Constitution actually uses. The idea is a fortress. The text is a single locked gate in one wall of it. Watch how the courts turn that one gate into the entire fortress. To understand the 11th Amendment, you have to understand that it is an answer, it is a correction, aimed at a single Supreme Court decision the country could not stomach. The year is 1793, the Constitution is 4 years old, the ink barely dry, and nobody yet knows how much of it is real. A man named Chisholm, acting as the executor of a South Carolina merchant's estate, sues the state of Georgia directly in the Supreme Court to collect a debt left over from the Revolutionary War. Georgia is outraged. It refuses even to appear, taking the position that it is a sovereign state and simply cannot be dragged into court by a private individual from somewhere else. And the Supreme Court, in Chisholm v. Georgia, rules against Georgia. It holds that the state can be sued. Justice Wilson put it about as plainly as it can be put. Here is the holding. Verbatim, quote, "I am clearly of opinion that a state is suable by citizens of another state," end quote. Look at how the court got there. Article 3 of the Constitution, the one that sets out the judicial power, lists among the controversies the federal courts can hear those between a state and citizens of another state. Chisholm was a citizen of another state suing a state. The text said the courts were open to exactly that, and the court took the text at its word. On the page, it was almost mechanical. The reaction was immediate, and it was furious. Remember the moment the states had come out of the Revolution buried in debt, and the notion that any creditor from any state could now haul them into a federal court to collect was, to them, a financial and political threat of the first order. It looked like the new national judiciary reaching straight into state treasuries. So the response was fast. Within a few years, the 11th Amendment was proposed and ratified for the express, stated purpose of overruling Chisholm. And notice how precisely it is drafted to do that one job. It closes exactly the door Chisholm opened, and no wider suit against a state by a citizen of another state or by a foreign subject. That is the fact pattern in Chisholm, reproduced almost line for line and then forbidden. It is a targeted repair to a single decision. On its face, it does nothing more than that. Here is where the doctrine leaves the text behind, and it is worth watching the exact moment it happens. If the 11th Amendment is really just a narrow repair of Chisholm, then it should only bar suits by out-of-staters and foreigners. A citizen suing his own home state should be completely untouched by it. The words do not reach him. That precise case arrived in 1890, Hans versus Louisiana. Hans was a citizen of Louisiana. He sued Louisiana, his own state, in federal court on a claim that arose under the Constitution of the United States. Hold his suit up against the words of the amendment and it is not covered. He is not a citizen of another state. He is plainly not a foreign subject. He pointed this out. And the court actually conceded that the text was on his side. It admitted that if you read the amendment literally, his suit, in the court's words, might be maintainable. And then the court refused to read it literally. What the court did in Hans was decide that the 11th Amendment was not the whole story. that it was only the visible tip of something larger. It treated the amendment as a partial expression of a much older and deeper principle, that a sovereign simply cannot be sued without its consent, period. A principle the framers had assumed silently in the background and never thought they needed to write down. To make the point, the court reached back to Alexander Hamilton, quoting the Federalist, and adopted this as its own, quote, "It is inherent in the nature of sovereignty not to be amenable to the suit of an individual without its consent," end quote. And then the court delivered its own conclusion in language that travels miles past anything actually in the amendment. Here it is, verbatim, quote, "The suability of a state without its consent was a thing unknown to the law," end quote. Unknown to the law, not barred by the 11th Amendment, unknown, pre-existing, simply assumed to be true before anyone wrote an amendment at all. And the court gave a reason that tells you everything about how it was reasoning. It said that reading the amendment literally would produce, this is its word, an anomalous result. Quoting the court, it would mean that in cases arising under the Constitution or laws of the United States, a state may be sued in the federal courts by its own citizens, though it cannot be sued for a like cause of action by the citizens of other states or of a foreign state. Put simply, the court found it strange to imagine a constitution that shields states from outsiders but leaves them exposed to their own residents. Strange, perhaps. But strange is not the same as wrong, and that is exactly what the text says. Faced with a choice between the words on the page and the background principle it believed those words stood for, the court chose the principle. That is why Hans is the hinge the entire modern doctrine turns on. It is the moment sovereign immunity stopped being about the sentence in the Constitution and became about an idea sitting behind it.
En what hekeltefafai kina fusions, tola how can reach a company who has a laser to major magni.
And notice what kind of protection Hans turned this into. It is immunity, not a black hole, and the word matters. A state can consent, it can waive its immunity and let itself be sued, it can agree by its own statute to answer in its own courts, and Congress, in the right and narrow circumstances, can lift it. So the door is not welded shut, but it opens only from the inside, at the state's own choosing. Which means the practical weight of the doctrine lands on ordinary people who hold a real federal right and find they have no way to enforce it for money against the very state that violated it, unless that state graciously agrees to be held to account. Hold on to that, because it is the human cost hiding inside an abstract-sounding rule. Okay, now run that same idea forward a full century to the second move. What happens when Congress itself tries to pry the courthouse door open? If sovereign immunity were only about the 11th Amendment's narrow text, you might think Congress could authorize suits against states when it legislates in an area the Constitution hands to federal power. In 1996, in Seminole Tribe of Florida versus Florida, the court said no. Congress had passed a law letting Indian tribes sue a state in federal court to force it to negotiate in good faith over gaming compacts, and Congress could not possibly have been clearer that it intended to allow those suits. The court struck the provision down anyway. Here is the holding in the court's own words, quote, "Notwithstanding Congress's clear intent to abrogate the state's sovereign immunity, the Indian Commerce Clause does not grant Congress that power, and therefore the statute cannot grant jurisdiction over a state that does not consent to be sued," end quote. And then the court stated the principle at its full width. Verbatim, quote, "Even when the Constitution vests in Congress complete lawmaking authority over a particular area, the 11th Amendment prevents congressional authorization of suits by private parties against unconsenting states," end quote. Sit for a second with how far that sentence is from the text it claims to enforce. The amendment names two things: citizens of another state and foreign subjects. This holding is about private parties of any kind and about Congress, and Congress is a word that appears nowhere in the 11th Amendment. The court has taken a sentence written to overturn one 1793 debt case and built from it a structural rule of the federal system. Two quick clarifications so that holding lands cleanly. First, that word abrogate, it just means Congress overriding the immunity, using a statute to strip a state of its shield and expose it to suit. Seminole Tribe says Congress cannot do that with its ordinary Article I powers, the commerce powers that carry most of federal law. Second, the court has left one lane expressly open. When Congress legislates to enforce the guarantees of the 14th Amendment, the amendment written after the Civil War for the specific purpose of restraining the states, it can abrogate immunity. That comes from Fitzpatrick versus Bitzer, decided in 1976, and it makes sense on its own terms. An amendment designed to move power away from the states carries with it the power to hold states accountable. Now, if this episode had been written a few years ago, that is where the story would stop, and the summary would be, Article 1, no 14th Amendment, yes everything else, shut. That summary is now wrong, and the way it became wrong is the most interesting thing about this amendment right now. Start with the reaffirmation, because it came first. In 2020, in Allen versus Cooper, the court had every opportunity to loosen Seminole Tribe and declined. Congress had passed a statute letting copyright holders sue states for infringement, and it had said so unmistakably. The court struck it down anyway, holding that Article 1's copyright power cannot support abrogation and that the statute was not valid 14th Amendment enforcement legislation either. Along the way, it addressed an earlier bankruptcy decision that had allowed a state to be sued under an Article 1 power, and it confined that case sharply, calling it verbatim, quote, a good-for-one clause-only holding, end quote. So as of 2020, the rule looked more settled than ever. Then it moved. In 2021, Penn East Pipeline versus New Jersey, and in 2022, Torres versus Texas Department of Public Safety, the court recognized a different route entirely, one that is not abrogation at all. The idea is that when the states ratified the Constitution, they consented in advance to certain exercises of federal power and gave up their immunity as to those, as part of what the court calls the plan of the convention. Not Congress stripping the shield, the states having handed it over at the founding in the structure of the original document. Torres is the cleanest illustration. A state trooper who served in the Army Reserve was called up, was injured, and sued Texas under a federal statute protecting the employment rights of returning service members. Texas raised sovereign immunity, and the court held for the service member its reasoning in its own words. Upon entering the Union, the states implicitly agreed that their sovereignty would yield to federal policy to build and keep a national military. The test, taken from Penn East, asks whether the federal power at issue is, verbatim, quote, complete in itself, and the states consented to the exercise of that power in its entirety in the plan of the convention, end quote. And the court answered the categorical objection head-on, quote, congressional abrogation is not the only means of subjecting states to suit. States can also be sued if they have consented to suit in the plan of the convention, end quote. So the accurate current statement is not that Article 1 can never reach a state, it is narrower and stranger than that. Ordinary abrogation under Article 1 still fails. Seminole Tribe and Allen versus Cooper both hold the line. But where the court concludes that a particular federal power was surrendered to in advance at the founding, the immunity was never there to abrogate. Bankruptcy, federal eminent domain, and the war powers are the three the court has so far identified.
And he sued the Louisiana triumphalistic, so that relations in effect that she had gotten it wrong. Verbatim, quote, in my view, our sovereign immunity decisions have not followed a straight line, end quote.
She recounted that 2 years earlier she had described the bankruptcy exception as good for one clause only, and then wrote this, quote, I thought then that our precedents had shut the door on further Article 1 exceptions to state sovereign immunity, but Penn East proved me wrong, end quote. That is a justice of the Supreme Court in a published opinion saying that her own reading of where this doctrine stopped turned out to be mistaken within 2 years. If you want one sentence that captures why you should be careful stating this area confidently, that is the sentence. And it is a useful discipline for the rest of us when a member of the court says the line has not been straight.
Do not draw it straight in a brief.
So here is the thesis, and it is a precise one. The 11th Amendment has a narrow text and an expansive doctrine, and the gap between them may be the widest in the entire Constitution. The words bar a single specific configuration, an outsider suing a state. The doctrine bars whole categories the words never touch, a citizen suing his own state, the way Hans could not, and a suit that Congress deliberately and explicitly authorized, the way the tribe suit failed in Seminole Tribe. And the engine of that expansion is one particular move, a move you should be able to name now that you have watched it happen. The court read a background principle into a specific provision. It decided the amendment was not creating sovereign immunity, but merely acknowledging a slice of it. Once immunity is treated as a pre-constitutional principle rather than a written rule, its edges get set by the idea, not by the sentence. The text stopped being the limit on the immunity and became mere evidence of it. And notice the twist at the end of that logic, because it cuts both ways. If the immunity comes from a background principle rather than from the text, then the question of how far it reaches is a question about what the states agreed to at the founding. That is exactly the reasoning Penn East and Torres used, and it is what let those cases find waivers the text never mentions either. The same move that expanded the immunity past its words is now, occasionally, the move that limits it. A doctrine unmoored from text drifts in both directions. You can also measure the size of the gap by the escape hatch the courts themselves had to build. Because states ordinarily cannot be sued, there is a long-standing rule from Ex parte Young, decided in 1908, that lets you sue a state official by name to stop an ongoing violation of federal law. You sue the officer, not the state, and the courts treat that as a different thing, even though it is unmistakably the state's conduct at issue and the state's policy you are trying to halt. Think about what that workaround tells you. The immunity grew so broad that the legal system needed a side door just to keep federal law enforceable against states at all. And know the limits of that side door because they are real. Ex parte Young gets you prospective relief only. You can stop an ongoing violation going forward. You cannot get damages for what already happened. It does not reach claims that a state violated its own state law. And where Congress has built a detailed remedial scheme of its own, Seminole Tribe holds that a plaintiff cannot bypass that scheme by suing an officer instead. So the side door is narrow, it is one-directional, and it does not carry money. Make it concrete for one moment. Suppose you work for a state agency and it violates a federal employment law. It denies you overtime that a federal statute guarantees, or it discriminates against you in a way federal law plainly forbids. You have a genuine federal right. You go to federal court for the back pay you are owed, and the state raises its sovereign immunity, and unless Congress validly lifted it, or the state consented, or the power Congress used is one the states surrendered at the founding, your claim for money damages against the state is simply gone. Not because your right was not violated, because of who you are suing. That is the doctrine's reach measured in a single ordinary life. The same words written to stop an 18th century creditor from collecting a war debt now help decide whether a state worker gets paid what federal law says they are owed, and as Torres shows, whether they do can turn on which enumerated power Congress happened to legislate under, which is not a distinction any of those workers would recognize as being about them. That is the sample. A full Amendment 11 season on this show would take the sovereign immunity story clause by clause and case by case, the original meaning fight over whether Hans read the history correctly in the first place, the abrogation doctrine, and the congruence and proportionality test that decides whether a statute is valid 14th Amendment enforcement, the plan of the convention cases and how far that reasoning can travel, the ex parte Young workaround, and exactly where its limits fall, and the way immunity has been stretched into state courts and into proceedings before federal agencies. One doctrinal question per episode, each anchored in cases we verify, not cases we remember. A quick word on how this show works. Everything you just heard is legal education, not legal advice. We are teaching how the doctrine moves, not telling you what to do if you are ever the person trying to sue a state. And everything is built on real, named, verified cases. Chisholm, Hans, ex parte Young, Fitzpatrick, Seminole Tribe, Allen versus Cooper, Penn East, and Torres were all pulled from the court's own opinions before I wrote a single word, and every citation is in the show notes. That is the whole ethos, and it is the name of the show. Do it for the case law. I'll see you at the next amendment.